volume 2,
Page.
page 113. Para 97, sir. The Silva has been extensively quoted. Therefore, every state in this country has internal sovereignty.
Para?
Para 97. PDF page 113. The Silva has been quoted extensively. I don't wish to read that entire portion. But kindly see B clause, the subpara B on page, PDF page, next page, Your Lordship, 114. The Parliament's power to alter the boundaries of states without their consent is a breach of federal principle. And subpara D, external sovereignty is not relevant to the federal nature of a constitution, for such sovereignty must belong to the country as a whole. But the division of internal sovereignty by a distribution of legislative powers is an essential feature of federalism, and our constitution possesses that feature. Now, if this is so with regard to the other states, much greater weight must be applied to J&K constitution.
Yes, Mr.
So in Santosh Gupta's case, 2017 2S, which Your Lordship will find in volume 1, PDF page 136.
What are you citing it for?
This is because this judgment says that J&K sovereignty has come to an end. Probably the Union of India wants to rely upon that. That is how it has come in the. So I wish to point out to Your Lordship that what was the issue in this matter? The issue was whether the provisions of the Surface Act applied to J&K or not. There was a constitutional challenge, which was upheld by the High Court. And the High Court referred to in the judgment several times the sovereignty of the J&K. And also said that this does not fall within the list 1. Now this judgment takes a view, if Your Lordships look at paragraph 43 and 44 at PDF pages 133. That Surface Act falls principally within the provisions of, within the ambit of entry 45 and entry 95, list 1. That's the finding in paras 43 and 44. Now, having come to this conclusion, that since it falls in entry 45 and 95 of the list 1, the question whether J&K constitution had sovereignty or not does not survive for consideration. Therefore, this is an arbiter. Applying the test which Chief Justice Chagla applied in that Bombay judgment. which incidentally I forgot to refer. It is there in volume 29.
We look at it, yes.
I just read out. Page 5 of that. This is what his lordship. But the question still remains as to what is an obiter dictum, given expression to by the Supreme Court, which is binding upon the courts in India. Now, an obiter dictum is an expression of opinion or point, which is not necessary for the decision of a case. This very definition draws a clear distinction between a point which is necessary for the determination of a case and a point which is not necessary for the determination of the case. But in both cases, points must arise for the determination of the court. Two questions may arise before the court for determination. The court may determine both, although only one of them may be necessary for the ultimate decision of the case. The question which was not necessary for the determination of the case would be ratio decision. The opinion of the tribunal on the question which was not necessary to decide would be only an arbiter. And I don't think that this view can be found fault with. So therefore, in para 47 in Santosh Gupta's case, his lordship says that sovereignty has come to an end. In the first place, this is clearly contrary to in Premnath Kaul's case, which has been cited by Mr. Dhawan. I just want to show to your lordship only one observation from Premnath Kaul's case that your lordship will find. That is para 16 of that judgment. What is the PDF page? Well, second line from the top, we have no doubt that the Juraj was perfectly competent to issue the proclamation of 20th April 1951, under which the Constituent Assembly ultimately came to be elected and convened. If the Constituent Assembly was properly constituted and it decided not to pay any compensation to the landlords, it is difficult to understand how the validity of these decisions can effectively be challenged. Your lordships have specifically recognized the power to convene a Constituent Assembly. That's an act of sovereignty. So there is one more para. He has read para 42. Who has read? Yeah. I'm sorry, I read para 42, not para 16. I stand corrected. So therefore, in my respectful submission, the observations in para 47 in Santosh Gupta's case to the effect that the sovereignty has come to an end is clearly contrary to Premnath Kaul's case. In any case, it's an arbiter. In any case, there is not much of discussion in that judgment on this issue. And it's a judgment of only bench of 2 learned judges. So my next point is Article 356. Much has been said by Mr. Dave and others, but there is one aspect which I want to bring to your highlight. It may be an overlap, but there is particular aspect which I want to emphasize. What is the effect of the presidential proclamation? Kindly turn to Article 355. What is the purpose of 346 or 356? There is breakdown of the machinery, accepted. The affairs of the state cannot be carried on in accordance with the constitution, accepted. Does that justify doing something which is unconstitutional? In the first place, the J&K assembly was dissolved in November 2018 and the governor assumed the powers. He assumed the powers under the J&K constitution. Not the 356 proclamation came in December 2018. This presidential proclamation under 356 is clearly without jurisdiction. Clearly without jurisdiction. The reason is that the governor has already dissolved the assembly. The governor has assumed all the powers of the state. Now, certainly the governor assuming the powers can't be a breakdown of the state machinery. It would be absurd to suggest that, and therefore President has to intervene under 356. It's a jurisdictional issue. And 356 has been invoked for a collateral purpose. And that collateral purpose is apparent on the face of the record. To suspend the two provisos to Article 3. The first proviso which applies to all the states, that you can't alter the boundaries, change the name of the state, etc., without first giving an opportunity to the state concerned to express its views through its legislative assembly. You suspend that. Second proviso which applies to J&K without the consent of the legislative assembly of J&K. Now I cannot understand if there is breakdown of the machinery, what is the necessity, what is the rational nexus to suspending these provisos? There is an implied limitation on this power. Can you suspend the entire constitution? Because the president has issued proclamation under 356. Once you accept that there are implied limitations, the suspension of any part of the constitution as a result of presidential proclamation under 356 must have a rational nexus to the objective that is to be achieved. And the objective that is to be achieved is Article 355. Kindly see Article 355. The duty of the center. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Now read Article 355, 356, 357 conjointly. And the only result is that the state as an constitutional entity must survive. What is the purpose of suspending the proviso? Ultimate design is abolishing the state of J&K. Contrary to the mandate of 355. Therefore, your Lordship will see the J&K Reorganization Act is born, is conceived in an unconstitutionality. Patent. Let me test even the wording. I have shown to your lordship the context, but kindly see what 357 says. Sorry, 356C. Make such incidental and consequential provisions as appear to the President necessary or desirable in giving effect to the objects of the proclamation. Now, suspension of those provisos, what is the nexus? In the entire affidavit of the Union, I don't find any light being thrown on this aspect of the matter. Then kindly see 357. One B. For Parliament or for the President or other authority in whom such power to make laws is vested under subclause A to make laws conferring powers and imposing duties or authorizing the conferring of powers and the imposition of duties upon the Union or officers and authorities thereof. Now this is a power to make law. The way Dr. Dhawan, everybody has argued that 356 is a temporary thing.
भाई को पूछो कि क्या
This that the power or the function that the state assembly performs under the provisos to Article 3 are not power of making law. Article 357, 356, they refer to the state legislature's power to make law, which is taken over by the Parliament or by President by issuance of ordinance. But this is not that power. The power under proviso is not law-making power at all. And this is recognized by judgment in Vishwananda Bharati's case. Again, I have to refer to Justice Khanna's just observation. And that is para 1351. which volume 15, PDF 542. So this is with reference to proviso to Article 368, but the logic would equally apply to proviso to 3, Article 3, my submission.
And your argument is that 357(1)(a) provides for Parliament to confer on the President the power of the legislature of the state to make laws.
Make laws.
And that function which you discharge under the proviso to Article 3 is not the power to make laws. We got it.
Not lawmaking power.
We made the point.
Yeah.
What's the next?
So therefore, it can't get the president can't take over that power.
Just give us the
1351.
volume.
1351. Articles 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the constitution were such a legislative process, the provisions regarding ratification by the legislature of states.
What is the PDF page? PDF page?
542.
Yes.
Article 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the constitution were such a legislative process, the provisions regarding ratification by the legislature of not less than one half of the states in respect of certain amendments, the constitution would be meaningless because there is no question of ratification of a legislation made by the parliament in exercise of the powers conferred by Article 248 read with entry 97 list 1. It is noteworthy that the ratification is by means of a resolution by the state legislature. The passing of a resolution can plainly be not considered to be a legislative process for making a law. The state government also do not come into the picture for the purpose of ratification, etc. So therefore, your lordship sees that everything that the legislature does is not necessarily law-making process. So therefore, the powers under the proviso would have never been taken. So therefore, Article 356 proclamation suspending those two provisos which have no nexus whatsoever to the object to be achieved under 356 clearly collateral. So now I come to interpretation of Article 3 and 4. So the reference I made to Article 355, but some passage from Bomai I must show to your lordship. PDF page 155
of
volume 2. Now kindly see what that para says. This is with reference to Article 355 on which I place reliance. That the purpose of 356 is to restore the state. Para 160. The crux of the question.
Just 1 second. Which page are you reading? 155.
The PDF page 155.
which judgment is this?
Bomai.
Volume 2. Para 168.
Para
160.
160. I think judgment of K. Ramaswamy. The crux of the question is wields of the President's power under Article 356. This has a direct bearing. It finds its birth from a family of emergency provisions in Part 18 of the Constitution. Article 355 imposes duty on the Union to protect states against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. As a corollary, when the government of the state is not being carried out in accordance with the provisions of the Constitution, a constitutional duty and responsibility is put on the Union to set it right. Therefore, if the machinery has broken down, to set it right means to see that the state normalcy is restored. Therefore, Article 356 cannot be read in isolation. The purpose of 356 is to restore under Article 355. That's the purpose for which. Now, another reason to say the same thing is said by Justice Jeevan Reddy and paragraph 272 and Justice Sawant at para 56, 57. I did not read those paras, I'm just giving to your lordship those parameters. So the sum and substance of BOMA is this, that restore the state to normalcy because that's a duty cast upon you under Article 355. Now there is one more reason to say that the exercise of power under 356 is for a collateral purpose. Because ultimately what they want to achieve, get away with, do away with Jammu and Kashmir state. That point I already made. I have also said no jurisdiction because the governor had already assumed the powers after the assembly was dissolved. There is one more reason which is to be found in judgment of this court in K.N. Rajgopal versus Karunanidhi. 1972, volume 4 SCC, page 733. PDF page 6869.
Of which volume?
So PDF page 6869, volume 19. It's a one-page judgment, but has seminal contents.
Volume 19.
Paragraph, there is only one-page judgment. It is volume 19, PDF page 6869. So this is what your lordships have said. We have just delivered a judgment in so and so. A similar question arises in this appeal, but with respect to the Chief Minister and the Minister of the State of Tamil Nadu, the relevant articles are worded similarly. The only difference is that the governor is not elected, but is appointed by the President under Article 155 of the Constitution and under Article 356 of the Constitution, makes a provision in case of failure of constitutional machinery in the state. But when an assembly is dissolved, there is no failure of the constitutional machinery within Article 356, Article 164, which provides that the Council of Ministers shall be collectively responsible to the Legislative Assembly of the state, has to be read in Article 75(3). Following our reasoning in that appeal, this appeal was. In other words, what your lordships have said is that once the assembly is dissolved, there is no question of machinery having failed, and therefore, consequently, there can't be a 356 exercise. So, in this context, I invite your lordship's attention to in Gujarat Assembly case. Now, if your lordships have a look at Article 356, there is no provision which says that what is the upper limit. How long you can do away without an elected government. This question came up before your lordship in Gujarat Assembly case. And your lordships have said 6 months. I just said that judgment is in volume 19, PDF page.
Page. Volume 19 page.
Does it?
Page, volume 19 page.
I'm just reading. Page 283. Which is the parallel?
Volume 18 page 28.
Kindly come to para 79 on PDF page. PDF page. 283, sir. 283. Para 79. However, we are of the view that the employment of the words and expiration occurring in section 14 and 15 of the Representation of the People Act respectively show that the Election Commission is required to take steps for holding elections immediately on expiration of the term of the Assembly or its dissolution, although no period has been provided for. Yet, there is another indication in section 14 and 15 of the Representation of the People Act that the election process can be set in motion by issuing of notification prior to the expiry of 6 months of the normal term of the House of the People or the Legislative Assembly. Clause 1 of Article 172 provides that while promulgation of emergencies is in operation, Parliament may by law extend the duration of the Legislative Assembly not exceeding 1 year at a time, and this period shall not in any case extend beyond a period of 6 months after the promulgation has ceased to operate. Further, under Article 123(2)(1)(3) of the life of an ordinance promulgated either by the President or by the Governor, as the case may be, is 6 months, and repeated promulgation of ordinance after 6 months has been welcomed by this court. Again, under Article 109, 110, and 111, and analogous articles for the State Assembly, money bill has to be passed by the House of the People or by the Legislature. So the period of 6 months has been read by your lordships. Then there is one more para of in the same judgment. This was of Justice Khare, and there is para 147 in the judgment of Justice Prasad. PDF page 316. So this is the ratio. Para 147. Almost his lordship has echoed what Justice Khare has written in the 79, which I read out. Now I come to Article 3 and 4. Kindly see the marginal heading. Formation of new states and alteration of areas, boundaries, or names of the existing states. This is a clue. Of course, there is a debate whether marginal headings can be seen or not. But fortunately for us, this issue is no longer res integra, as a constitution bench judgment of this court in Bengal Immunity versus State of BR 1955 2 SCR, page 603, or AIR 1955.
What will be the PDF page and volume?
PDF volume 13, and page is PDF page is 144, and I take straight away your lordship to para 25.
It can indicate the general drift of the provision, but it cannot be used to supplant the actual statute.
That's correct.
The
I'm not
actual
saying-
words of the provision.
I'm not saying. If there is some ambiguity, and there is in my respectful submission, according to me, there is not even ambiguity, there is a conscious omission in Article 3 as regards power to abolish a state. Conscious omission. So why do I say there is a conscious omission? Not only from the marginal heading, but also look at the text. Form a new state by separation of territory from any state or by uniting two or more states or parts of the state or by uniting the territory to a part of a new state. Minute details, what that power is. Then it further says, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Details are given. What is the extent of that power? There is no ambiguity at all. There is not even a whisper about abolishing a state. And this has to be seen in the light of Article 1. India, that is Bharat, shall be a union of states. Also, Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. So Article 1, India, that is Bharat, is the union of states. Article 2, admission of new states. Article 3 gives details of the power that the Parliament has. Therefore, there is a conscious omission to abolish a state. My second point.
What happens when you unite two states?
But the point is this, your lordship will see that a territory, what is the idea behind the state? That people in a given territory should have a state government. Two-tier democracy at the state level, and that is how the constitutional scheme is. Some powers are given to the state, list 2. They have their own government. So this concept of a state is inbuilt in a democratic structure that this constitution has built. In other words, the existence of states is a part of the basic structure. And J&K can't be an exception to it. Then why not tomorrow abolish Bengal? What parameter? that according to me, there is a conscious omission. So Article 1, 2, 3 have to be read together. Now, there is one more reason. This alteration of boundaries, changing the name of the state, uniting two states, one state being divided into number of states, this does not amount to an amendment of the Constitution. True. So all the more reason why this power must be narrowly construed. According to me, no two interpretations are possible. There is a conscious omission to abolish a state because India is the union of states. I link it with 355 and 356. Article 3 has to be read with 355. If there is breakdown of machinery, restore the normalcy. But you can't abolish a state. And since it does not amount to a constitutional amendment, it must be strictly, narrowly construed. And this interpretation, in my respectful submission, would advance the concept of democracy and concept of federalism. Open the Article 89, Article 80. Of my argument. Now forget everything. What is the impact on the constitutional structure where everything has been turned upside down? First, what is the impact? Ladakh under the reorganization has no representative in the Rajya Sabha. People of Ladakh therefore do not count as far as Rajya Sabha is concerned. So much for the democracy. Now look at Lok Sabha. All existing Rajya Sabha. All existing 4 seats in Rajya Sabha go to J&K. Ladakh is left out. Consequently, people of Ladakh have nothing to do with working of Rajya Sabha, including the election of the deputy chairman under Article 89 and 90. Second, look at Lok Sabha. Under Article 81C, all union territories in the country can maximum have 20 seats. In that, you have the J&K. But look at the discrimination. Under Article 81, Clause 2, as far as other states are concerned, the number of seats that they have depends upon their population. And the Constitution further mandates that this ratio between the population and the seats for all the states shall be same as far as practicable. So in state of Jammu and Kashmir, irrespective of its population, it has no proportionate representation in the Lok Sabha. Discrimination. Article 14. Now, if you create some more union territories, that limit of 20 will have to be crossed. Today it is 19, including the 5. That's all right. But look, if working out seats for other states is a different formula. How can this be done? Other disastrous consequences. Look at the election of the president. Come to Article 54 and 55. For electing the president, the electorate consists of members of parliament, both Rajya Sabha, Lok Sabha, and also the legislative members of respective states. Now, J&K is not a state. Therefore, there is no MLA for the purpose of president's election. Now, to the exclusion of such a big area, no say in the election of the president, if not by direct, at least by an indirect method. But I must hasten to add that the Reorganization Act says that J&K will have the same rights as Pondicherry. And Pondicherry under Article 54 and 53 there, but this will require a constitutional amendment. You can't do it by law like this. Other disastrous consequences, Article 279A, representation in the GST Council. People of Jammu, Kashmir, Ladakh have no say as far as that council is concerned. Appointment of High Court judges. As far as other states are concerned, the governor is one of the persons to be consulted, and governor means aid and advice. So that also goes away. There are several such provisions in the Constitution which are impacted. Therefore, by a very small act which apparently looks constitutional, that is Constitutional Order 272, the whole constitutional structure is demolished, substantially restructured. With J&K. I'm grateful that
Thank you, Mr.
I exceeded my time.
No, Mr. Nakde. Thank you very much. Thank you, Mr.
And
Nakde.
both Mr. Dave and everybody has argued that consultation contemplated must be effective. That is why elected. That point has been extensively argued. So I'm sorry that I exceeded my 1 hour.
Thank you, Mr. Nakde. Thank you.
I thought in the circumstances, perhaps I was justified. I am grateful.
Somebody's time will have to get deducted.
Ultimately, whether it's 20 over, 50 over, the time is allocated to everyone between whatever is available.
How much somebody can bat will depend on the total number of hours.
Since your lordship used the word bat, Lord, it reminds me of my position at this point of time is like that of a night watchman.
No, you're just after tea, actually, so you have a whole session, you can resume.
Which is a very delicate job, night watchman, no? He has to sustain the flagging interest also. Lord, I have submissions on 2 issues only. One was what Mr. Nakde was advocating just now regarding demolition of a state into union territory. And the only thing I wish to add on what he said was, if Lordship would just have a look at 246(4).
Is it way?
Which matter are you appearing, Mr. Devadi?
रेट नंबर दे दो इनका.
So,
That is
in the first matter, we filed a petition, but we were told to file a intervention application. And then an order was passed on that we will be heard like any other petitioner, therefore.
So you are for an intervener,
Yes.
which just give us there's a reference so that, we can, just for the sake of the record, we need to complete the record.
Lord, it is writ petition number, it is IA number 145.
IA number,
2.
sorry, can you come again, please?
IA number 145
Yes,
852
yes.
-53 of 2019. This
In-
is in writ petition civil number 1013 of 2019.
Actually, 18 forgot to
overruling note inevitably implies that the past practice, whether right or wrong, it will continue to operate and will not be affected by the judgment. But it accepts the fact that if the declaration is made of invalidity of the impugned amendments, then that may have a consequence, and therefore lordships prospectively overrule it. So implicit in this prospective overruling is the invalidity of those supposed invalidity, and therefore lordships try to save it. Now, another way of looking at it is look at it this way. Supposing lordships accept my viewpoint on the basis of the text and the context, and lordships come to the conclusion that yes, there is a case for this, that the power is not available, and therefore the impugned COs are invalid. Now, in order to prevent the effect from traversing on to the earlier ones, your lordship would ask whatever relief lordships can mold under about 142, lordship would do that. But that doesn't mean that on the basis of this past continued exercise of power, your lordships would ignore the text and the context. If the text and the context, as per my submission, inevitably show that yes, the power could not have survived beyond 57, then perhaps there is a case to look into it.
All right, now, Mr. Devadi, should we start with the first point? Because first you have to add on to what has been argued by Mr. So maybe just because we are at about 3:35, so you can maybe in 5 or 10 minutes conclude the first point.
What I wanted to add was, apart from what my friend had said, additionally, if your lordship would just have a look at 246(4). Lordships have had a look at it on several occasions, but then my friend perhaps omitted to see it. 246(4). Parliament has power to make laws with respect to any of the matter for any of the territory of India, which is union territory, not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Now, that's the inevitable consequence of when you break down the state into a union territory, then Parliament is the sole legislature. Now, when Parliament becomes the sole legislature, then inevitably, the state comes out of the federal structure. So the lordships have said, Article 1, and my friends read some part of it, I can read some part of it too. Article 1 says India is a union of state and refers to Schedule 1. I feel lordship would just have Schedule 1 for a moment. Now, Schedule 1 specifies the states in Article 1 and 4. First schedule. It specifies the states, and Kashmir is there at item 15. And then, it goes on to have item 2. The lordship would have 28 states, then item 2, union territories. These are not specified as states. Now, though they are part of territory of India, as per Article 1, yet when it comes to federal structure, union territories are not part of that federal structure. This is there are decisions I have referred to in my judgment, but the decision to that effect, that Article 1 does not contemplate union territory constituting part of federal structure. And for obvious reason, if your lordship would recall the definition of federal structure in our constitution given by Dr. Ambedkar, he said there has to be a dual polity. And that is how he declined the entire objections to the Constitution of India as being unitary and not being federal.
Now there is a nuance on that. Following the NCT judgment,
yes,
we have placed Delhi in a different.
And I was coming to that only. It goes further.
Position.
what your lordship has said goes further. What it says is that dual polity contemplates that citizen of every state is entitled to be governed by the laws made by two different legislatures. That's the concept of dual polity. Where for local issues, the right is for the local to get himself governed by the local legislature on local issues. And so far as the national issues or bigger issues are concerned, Parliament. That right gets defeated. And therefore, the dual polity gets lost as per Lordship's judgment. States are not appendages, as the Lordship said, not satellites of the Union. They are their own plenary selves created under the Constitution, not the Parliament. So this results in the demolition of the entire dual polity and therefore destruction of the federal structure. And no one can say, Lord, the Jammu and Kashmir did not satisfy the requirement of federal structure. Our federal structure is not defined, but there's an interesting aspect which I wanted to bring to your lordship's notice in this regard. Lord, all throughout, we have been hearing about the quasi-federal character and so on and so forth. It's not truly federal as the American system in our constitution. But in each of these judgments which say so, what your lordship would see is they omit to notice the constitution of Jammu and Kashmir. And when we come to constitution of Jammu and Kashmir, it goes one step ahead of any other constitution. And that is this. It is the constitution of Jammu and Kashmir in our federal structure which lays down the parliamentary jurisdiction. It lays down the parliamentary jurisdiction under the commitment given by the framers of the Constitution and the Dominion of India. It lays down the tone and terror of the state and the union relations. Finally, that's what the framers have said. And then have a look at Section 5. Because if we don't accept this fact, then Section 5 becomes, which is according to me, the soul and heart of the JK Constitution. That gets absolutely demolished. That's the basic structure of the JK Constitution. And Section 5 says the power of state would be not on any subject which is given to the Parliament. Parliament has been given enumerated powers, that is entry 1 to 96, not 97 and Article 248. So which means residuary entry is not there. Rest of the entries 1 to 96 are there.